Hi, I'm Pete Fellows of Fellows and Associates. We're an IP recruitment and social media company. I'm here on behalf of Careers and Ideas and IP Inclusive as part of the Summer in IP initiative. In conjunction with IP firm Hamzo, we are running a series of interviews with firms around the world to discuss opportunities outside the UK for graduates interested in IP. Today, I'm with Prue Cohen of FB Rice. Prue is a registered Australian and New Zealand patent attorney and partner in FB Rice's Melbourne office. Can you briefly describe your firm and your role within it?
So FB Rice is an Australian and New Zealand IP firm with over 75 years experience. We provide a range of IP services, including patent and trademark prosecution, freedom to operate and landscape analysis, oppositions, litigation support, as well as R&D tax consulting. We work with a range of clients from startups to global corporations, and we actually have one of the largest patent teams in Australia and New Zealand, including the largest life sciences team in Australia. So I'm a partner and patent attorney in our biotechnology team, and I'm based in Melbourne. And I specialize in biopharmaceuticals, their uses and methods of manufacture.
So, which technical fields or industries do you work in most?
So I work primarily in the life sciences and biotechnology sector with a focus on pharmaceuticals and biological therapies. My practice includes technologies relating to antibodies and cell and gene therapies, as well as manufacturing processes for biological products. I also work in the diagnostic space together with other more broader molecular and cell biology innovations.
What type of clients do you typically represent?
I work with a range of clients and innovators, including universities, research institutes, startups, multinational corporates, and overseas associates.
Is that kind of true for the firm as well in terms of the...
Yes, so we tend to work for sole innovators as well as startups, spin-outs, universities, researchers, large corporates, a lot of foreign overseas originating work, but we do have one of the largest sort of locally based innovators and clients.
So how is the patent profession structured in Australia?
So in Australia, the patent attorney profession is regulated by the Trans-Tasman IP Attorneys Board, or the TTIPAB, which really oversees our registration standards in both Australia and New Zealand. So we are qualified as Trans-Tasman or Australian and New Zealand patent attorneys. To become a registered attorney, we need to complete a recognised STEM degree, either in science, technology, or engineering, and an accredited intellectual property coursework. And we also, in addition, need to undertake 2 years of supervised practical experience under the supervision of an experienced and qualified patent attorney. So the most common pathway into the profession is to join a firm as a trainee attorney or a technical assistant, whilst also completing the required studies and examination at university. Students typically work with a qualified attorney, taking on more and more responsibility whilst they complete their studies.
I was going to say, do any new entrants to the profession go the industry route from graduation, or is that very uncommon?
So from qualification as an attorney?
No, so before, so once they graduate university, instead of going to a firm, would they go in an in-house position immediately and then train as a patent attorney?
You can go in-house. It is a bit harder because you still need to have that 2 years experience and get sufficient experience under the supervision of a registered attorney. So provided that that in-house organisation has a registered patent attorney, then it's possible to do it in-house, but we don't see it as much here.
Okay.
The profession here is actually relatively small in Australia, so we are still a highly specialised profession compared to mainstream legal services, and we're very similar to the European, UK setup rather than the US legal system. So we really are a specialised industry here in Australia, and we do work either in professional law firms or in-house, as well as within research institutes or universities. So career progression is generally standard through most firms in Australia. So you typically start as a trainee attorney, progress through to associate, senior associate, and then through to partner or principal of a firm.
What are the usual qualification routes for someone entering the profession locally?
So in Australia, you need to have an accredited STEM degree, so typically a science, engineering, or technology degree, followed by a accredited IP course. So either a graduate diploma or a Masters of Intellectual Property undertaken at an accredited university.
Are foreign qualifications such as UK degrees or UK patent training recognised or taken into account typically by Australian firms?
Definitely. So foreign qualifications, including UK science or engineering degrees, are certainly well recognised in Australia, particularly where they align closely with Australian accreditation standards. UK patent training and experience is also often taken into account as relevant professional experience, although formal registration is still required as an Australian New Zealand patent attorney, and it still requires meeting local qualification and regulatory requirements. UK certainly do get recognition
Yeah.
for the UK exams, and European sort of get recognition.
So how common is it for UK graduates to move to Australia and then qualify as patent attorneys?
It's actually relatively common, particularly we do see juniors, graduates coming across to Australia, looking for opportunities, wanting to move to Australia, gain experience, enter the profession, and they do see it as an alternative route to enter the profession in Australia. Their UK qualifications are generally seen as positive, and particularly also any other experience that they may have in the industry coming from the UK.
And then what about UK qualified attorneys moving to Australia? How common is that?
We see that quite a bit. So particularly at the junior level or the mid-career level, we often see practitioners coming from the UK to Australia where they've received their qualifications overseas in the UK and then wanting to relocate. So even though we are quite a small industry in Australia, we're certainly internationally connected. And the experience that those attorneys have gained in the UK is viewed really positively. And if the candidates are able to demonstrate, which is quite often, their adaptability to Australian regulatory requirements and the practice environment, then we see them as certainly very valuable to the growth of our industry here in Australia.
How do you typically recruit new trainees or junior attorneys?
Typically, it's through a combination of direct applications from individuals or even referrals. So recruitment usually focuses on the academic foundation, so often trying to fill a gap within our technology field. We also focus on communication skills, commercial awareness, and also cultural fit for the firm as a whole, rather than expecting people, particularly graduates, to have a solid understanding or full formed of the IP system. So our process includes a range of interviews as well as written and analytical assessments.
How competitive is the entry level trainee market in Australia?
It's very competitive. So there are a few roles and there are a lot of graduates applying for these entry-level trainee positions in Australia. We like to see candidates with strong academic credentials, clear motivation for a career in IP. Some exposure to the industry is always a plus, but we understand that that may not be the case. But a willingness and an enthusiasm for the industry and the profession is always valued as well.
Do you hire on a regular cycle or more when needs arise?
It's a bit of both. So we usually have one standard intake per year, but sometimes it can be as needs basis, depending on the business requirements and whether or not we need additional trainees or we're looking for more mid-level qualified attorneys. So it depends on the circumstances at the time.
So what concerns do you have, if any, when considering UK graduates or UK qualified attorneys?
So the main considerations tend to relate to visa eligibility, also long-term commitment to Australian market, and also understanding the local qualification pathway and the time to qualification. So these are more practical requirements and barriers rather than capability-based concerns. But these are usually explored during our recruitment processes.
What does trainee training look like in Australia?
So I can only speak for FB Rice, although I would say it's this very similar across all firms. But trainee training is very workplace based and supervised alongside the formal study and obtaining those formal qualifications. So at FB Rice, our trainees work closely with experienced attorney. They receive structured mentoring and progressively take on more and more responsibility as their skills develop. Training is typically practical and it's supported by a learning and development framework within the firm, which includes dedicated tutorials, particularly for those latter subjects of drafting and INV.
And I would imagine if you have an intake at a regular period, they have a peer group around them or going through a similar kind of experience.
They do. So we like to have that structured approach to the hiring so that our trainee attorneys do have a supportive cohort through which they can go through the studies as well as progress through the firm together.
How long does qualification typically take?
So from commencement as a trainee, qualification typically takes around 2 to 3 years, remembering that there is a requirement for at least 2 years of supervised training as part of the regulatory requirements. The university course usually also takes about 2.5 years. So 2 to 3 years is standard for qualification.
How much support does FB Rice or anything you know about firms in general provide for exams, study leave, and mentoring?
So at FB Rice, we provide substantial support for our trainees, which includes paid study and exam leave, full financial assistance for course fees, as well as internal mentoring and tutorials and other learning and development support frameworks. And we do this because we recognise that supporting our trainees through qualification is essential to building their long-term capability in the profession, but also for FB Rice.
And is long-term retention of foreign trained attorneys reasonably common?
Yes, and I think at least at FB Rice, that's part of our hiring practices. We like to make sure that those that we hire from foreign jurisdictions, including the UK, are wanting to integrate into the Australian ecosystem, including the IP profession. So where individuals are able to transition successfully into the Australian system, we do see that there are a lot of long-term career opportunities locally and that they do stay once they are here and settled in Australia.
And I guess there's an investment in time for them to actually cross qualify, which hopefully means they're more likely to stay than if they didn't need to go through that.
Yeah, and we do find that the retention is highest when we have and we see that clear development pathway. So we see that, they're requalifying, they can see the career progression, and the candidates are generally interested in building that career and establishing themselves in the profession in Australia, rather than viewing it as just a short-term sabbatical or short-term option as part of their career.
Are visa or work permit issues a significant barrier when hiring from the UK?
They can add complexity, but they're not insurmountable. So Australia has a range of different skilled migration options, and UK nationals are often very well placed within our existing visa frameworks. The timing and planning of such visas is important, but they're generally viewed as manageable rather than prohibitive to hiring anybody from overseas, including the UK. I would certainly always check the rules of the country before making any application, and they do change. Our skilled migration options are constantly changing. It can depend on the environment, the needs. So I would certainly recommend people double check the visa requirements before making the transition and the move to Australia.
Has FB Rice previously sponsored visas for trainees or early career attorneys?
Yes, FB Rice has sponsored trainee attorneys and UK qualified attorneys visas in the past. So it is not a prohibitive to hiring at FB Rice. It is possible, obviously, any consideration of sponsorship depends on a clear business need. And we do like to see that demonstration of longer term commitment. And so every application is assessed on an individual basis rather than a standard practice.
What would you recommend UK students or attorneys do to improve their chances of being hired in Australia?
I would suggest that candidates clearly understand and articulate why they're interested in the Australian IP market. So that can include familiarising themselves with the local qualification requirements, the profession and the different firms and firm structures within the Australian market, and also demonstrate flexibility and openness to learning in that Australian market. One way of doing that is networking and informational interviews and gaining exposure to Australian clients, lawyers, IP professionals or practitioners where possible can also be really useful for gaining some insight into the Australian IP profession.
Are there common mistakes foreign candidates make when applying?
A common mistake is underestimating the importance of understanding the Australian IP profession and assuming that a UK qualification alone will translate directly to an Australian New Zealand qualification. So I certainly recommend that applicants demonstrate genuine research into the local market and have that long-term mindset to understand how the IP system works in Australia and that understanding of requalification in Australia.
We certainly see that the other direction as well, of people moving from international markets to the UK. So I think that's a pretty common experience.
I think part of the reason for that is other industries allow that transition. Like
Yes.
physios, for example, I believe that you can pretty much just go over, and Australian physios are always going to the UK, and they can go over and just work. So I think
So
sometimes people think, oh, I can just take my qualification with me.
would FB Rice be open to informal discussions with UK-based candidates interested in your jurisdiction, or is there more of a formal process for applications?
We are at FB Rice always open for candidates to reach out to any of our attorneys and open the pathway for discussions, either graduates or already qualified attorneys looking or interested in transitioning to the Australian IP market.
So thank you for joining me today, Prue, and thank you to FB Rice for supporting this initiative.
And thank you to you, Pete. It's been wonderful, and I think it's a great initiative.